Thank you, Joe. We're ready?
Yeah.
Good?
Just gonna turn the page over. One more. Very good. We single-sided you to make it easier.
Good evening to everyone here. I just wanted to welcome everyone to Borough Hall. On behalf of our Borough President, Eric L. Adams, this is a hearing to discuss 3 items on the agenda this evening. Please note that this hearing is being recorded to comply with the public law for transparency. It will be available for viewing on the website brooklyn_usa.org or on the One Brooklyn channel on YouTube. Web viewers may submit timely comments to Ask Eric at brooklynbp.nyc.gov for Borough President Adams' consideration. Please call the item and let us begin. And before you do that, Richard, I apologize. I just wanted to introduce myself. I'm Diana Reina, the Deputy Borough President. Thank you. After you.
All right, calendar item number 150167ZRY.
I want to recognize that we've been joined by Councilman Chaim Deutsch and former council member Lou Fiedler, who has joined us and is part of our Borough Hall staff family, and also our chair from Community Board 15, Teresa Scavo. Thank you for joining us. At this moment, the Department of City Planning, in collaboration with the Department of Buildings and Fire Department, is proposing a citywide zoning text amendment to facilitate and make effective additional safety measures that are part of New York City's 2014 Building Code. In Brooklyn, the text would be applicable in the high-density sections of Community District 2 for new construction of non-residential buildings in excess of 420 feet in height. Community Board 2 voted to approve this application by a vote of 38 in favor, 0 opposed, and 0 abstained. Would the representative for this application, Dakota Hendon, right? Please state your name for the record and present the application.
Sure. Good evening. My name is Dakota Hendon. I'm with the Department of City Planning Zoning Division. Today I'm here to talk about a citywide zoning text amendment that we've worked with the Department of Buildings and the Fire Department on that is part of the 2014 New York City Construction Code. These are intended to facilitate and make effective these additional safety measures. These safety measures are intended to enhance public safety in new high-rise non-residential buildings by providing additional exiting capacity for building occupants during emergency situations that require full building evacuation. These safety recommendations resulted from an extensive study by the National Institute of Standards and Technology of the World Trade Center disaster. The report recommended several changes to be incorporated into model building codes, including decreasing the time it takes to evacuate an entire building in an emergency, increasing the ability of first responders to access building occupants, and to provide greater redundancy in escape routes to ensure that if one route becomes unavailable, there are other routes to take. These changes were adopted into the New York City Building Code as part of Local Law 141 of 2013, otherwise known as the 2014 New York City Construction Codes. The law stipulates, however, that these safety provisions will only become effective once a text amendment is approved to exempt the space occupied by these features from counting towards zoning floor area. The proposed text amendment consists of an amendment to Section 1210 of the definitions of the New York City zoning resolution to exempt floor space that is occupied by these additional safety measures from counting towards zoning floor area. These safety measures are required for all new non-residential buildings that are greater than 420 feet in height, or mixed-use buildings that contain non-residential space above a height of 420 feet. Predominantly residential and fully residential buildings are not subject to the additional requirements and are not affected by this text amendment. Two common questions are often asked regarding the applicability of this amendment. The first is, why are residential buildings not included? There are several reasons why residential buildings are not included in this amendment. The first is the building code generally has more stringent egress requirements for non-residential buildings. This is mostly because of the higher density of occupants per floor in these types. Additionally, as part of the 2008 New York City Building Code, changes were made to increase the width of stairwells in residential buildings by 8 inches. A similar text amendment to what is proposed today was approved at that time as well. The other question that often comes up is, why do these requirements kick in at 420 feet? The height thresholds originate from the International Building Code, as do most of the requirements in the New York City Building Code. The International Code Council has an open and collaborative code writing process that is based on a consensus-based decision process. After extensive study, including the NIST report and input from numerous stakeholders, 420 feet was determined to be the appropriate height and is a threshold for a number of other requirements in the international construction codes. This amendment will affect a small amount of buildings. The examination of DOB records from 1997 to 2014 show that only 29 non-residential buildings over 420 feet tall were constructed, which is equivalent to less than 2 a year. Buildings of this size are typically found in zoning districts without set height limits and that allow a floor area ratio of 10 or greater. These districts can be found in Midtown and downtown Manhattan, downtown Brooklyn, and portions of Long Island City and Queens. Briefly summarized, Building Code Section 403.5.2 is a new provision requiring one of the following options be incorporated into the design of all new non-residential buildings in excess of 420 feet. Your first option is to construct all passenger elevators in the building as occupant self-evacuation type. Occupant evacuation elevators, or OEEs, are specifically designed to be operated during an emergency. They include special safety features that permit the use of the elevator during a fire or other similar emergencies. These features include connection to emergency standby power, fire-rated electrical connections, emergency communication systems, and special lobby dimensions to accommodate floor occupants. The second option is you can increase the required width of all emergency exit stairways by 25% above what was otherwise required and construct all passenger elevators as occupant evacuation types with standby power capable of running a portion of them based on an egress analysis. And then the third option, which is sort of the name of the text amendment, which is you can construct one additional emergency exit stairway than would otherwise be required. So if you have a 2 stairwell requirement, your option would be to construct an entire new stairwell. The above requirements resulted from extensive mediation that included all stakeholders in both the egress and elevator technical committees, and are based on, like I said, in the International Building Code. In order to determine the effect of the proposal, the department worked closely with DOB and studied several different building types and sizes. Depending on the design option selected from the building code requirements, the reconfiguration of total net floor area could result in slightly bulkier buildings, either with slightly larger floor plates or slightly increased height. To understand the net effect of this change, the department studied building types most likely to be affected by the proposed amendment. Of the 29 buildings built in the past 15 years, 18 are office, 10 are hotel, and 1 is a hospital. Therefore, office and hotels are the primary types of high-rise development affected by this action and were the focus of our analysis. The diagram indicates the typical fire safety exit stairways found in high-rise office and hotel developments. It illustrates the amount of floor space taken up by additional safety exit stairway varies in the different uses because of the floor-to-floor height. In an office, you typically have taller floor-to-floor dimensions, and therefore you have a slightly bigger square footage for the staircase. So in office, you're looking at about 184 square feet per additional stair, and in a hotel, more typical is about 141 square feet. The 25% additional width option results in about 52 or 43 square feet, respectively, per stairwell. And then the first option that I discussed, which was the all occupant evacuation elevators, has no net effect on the floor area. And so if you choose that option, there's no exemption. So getting into some examples, buildings with small footprints have a tight building core, and usually a small number of elevators are adequate to serve the building occupants. Because of the limited amount of square feet per floor, the designers of such buildings typically seek to maximize the amount of usable square footage. The provision of all occupant self-evacuation elevators occupies the least amount of usable floor area per floor, thus maximizing efficiency, and would therefore be the likely option for those small footprint buildings. The fact that fewer elevators are provided in small floor plate buildings also means construction costs associated with adding all OEEs is less. There's no floor area exemption for that option. However, on the small footprint office building hotel type shown here, even the maximum floor area deduction associated with an additional stairwell results in less than 3/4 of an additional floor. By contrast, high-rise buildings with medium and large floor plates need significantly more elevators to efficiently transport building occupants. Therefore, the added cost for all occupant evacuation elevators is greatly multiplied, and the provision of backup power for all the elevators is more expensive as well. Overall, development sites with larger floor plates allow the project designer a greater amount of design flexibility. The designer of these buildings would most likely choose either the 25% wider stairways or the additional exit stairway. The medium floor plate buildings shown, typical of smaller offices, results in between 1/2 and 3/4 of an additional story. The larger floor plate buildings, typical mostly of offices, will most likely choose the additional stair requirement because of the large efficiency of this floor plate size. However, the resulting exempted square footage is less than 1/2 a story because of the large size of the building, the actual floor plate at the upper level. In conclusion, the principal effects of the proposed text amendment would be the effectuation of improved safety requirements in new high-rise non-residential buildings. These requirements have been adopted by the International Building Code as well as several major cities around the country and resulted from lessons learned in our very own city.
Thank you very much for the explanation and the thorough presentation. I just wanted to start with a question regarding the number of buildings in legal noncompliance with this text throughout Brooklyn.
Okay. So we have data within the last 15 years. There was only one building that would, it's difficult to describe it just as legal non-compliant because these requirements would not, those buildings are not subject to the requirements, so they're still compliant with the building code that they were built under. But if we were to assume which buildings would this have applied to over the past 15 years, there's just one, which is 330 J Street, which is a non-residential building exceeding 420 feet.
And what input has the city received from the hotel and office sector developers?
So the way that the requirements were originally created was as part of a 3-year process. Every 3 years, the building code is being updated and includes stakeholders from every industry.
Okay.
So within the elevator and egress technical committees, there are representatives from, I think, almost every sector of both public and private entities, and the resulting, this section specifically was not able to be agreed upon. So it actually went into mediation. And so the result of the mediation was that this specific section of the building code actually has a separate effective date from the rest of the 2014 New York City Construction Code, and it is based either it's June 30th of this year or such time that a text amendment is passed. So the only way that they arrived at a sort of solution or a way of getting this moved forward is to say that it only will become effective upon approval of a text amendment.
Because they get the free floor.
Before June 30, June.
Once this is adopted, where this wasn't adopted, they get stuck on the floor area.
Got it. So permits are being issued at the buildings department up until June 30th, 2015, or upon the text amendment change, whichever comes first.
It's or whichever is later. So it won't become effective until June 30th, or if this process takes longer, then it will be subject to this process. Currently, we're on schedule to have it approved. Before that is our goal. We really like to see the safety measures in place.
So one could say that the Department of Buildings is going to continue to issue permits for construction without this text amendment up until
Yes,
it is set
exactly.
to change. And then those would be grandfathered in.
Yeah, well, they wouldn't be subject to the requirements, so they would still be compliant with the code that they were created under, but basically, yes.
And what is your presentation perhaps already touched upon this, but what is the rationale behind the additional stairwell option?
This is mostly just based on the World Trade Center disaster, but it has a number of ways of how the fire department deals with the disaster. So in the World Trade Center, some of the stairwells became unavailable, so this is just about creating greater redundancy in escape routes. But there also has been other reasons that the fire department typically doesn't require, the way that the stairwells are designed is not to allow full building evacuation in very high-rise buildings. The idea is that the fire department will actually stage a couple floors below the actual fire, and then they will take over a stairwell and just fight the fire from they'll kind of stage their equipment several floors below. And that's sort of the way that stairwells have been designed up until now. In light of recent events, the building codes are being updated to say there are other situations where full building evacuation is necessary, and therefore we should have either greater width in our stairwell so that more people can be evacuated quicker, and that in case one becomes unavailable, that there is another route.
Got it. I don't know if there's anyone in the audience who is here to testify on this land use matter. Seeing none, we are going to close this particular item, and we thank the Department of City Planning for the presentation, and our office will be in touch with the Department of City Planning. We see no reason to not be supportive.
Thank you.
Thank you.
Calendar item number 1 is closed. Calendar item number 2, 150109ZRK.
This applicant, Cherry Hill Gourmet Market, proposes to amend the zoning resolution to permit a food store with no limitation of size in Area B of the Special Sheepshead Bay District. This would allow the market to operate as a primary use in conformance with the regulations. Community Board 15 has not voted on this application yet. I will hold off on making any decisions until I hear from the board, which is having its hearing and board meeting on January 27th. And the chair herself is here and will be testifying upon, no? She will be here observing and making sure that her presence is felt. Would the representative for this application, Richard Lobel, please state your name for the record and present the application?
Richard Lobel from the law firm of Sheldon Lobel, PC, for the applicant. Madam Deputy Borough President, thank you so much for having us this evening, and it's a pleasure to be here with so many esteemed members of the Brooklyn community, as well as council members and former council members as well. I'm with Sam Nitka today from Cherry Hill Gourmet, and today we're presenting for a text amendment. And the text amendment would amend section 94061 of the zoning resolution of the City of New York. This section refers to the Special Sheepshead Bay District, which was enacted in 1973. And in an effort to basically enhance the commercial and other aspects of the Sheepshead Bay District, this text was passed back then. We're seeking to amend that text to allow for the Cherry Hill Gourmet Market in this building, which you see to my left. Cherry Hill Gourmet has been at this site since 2007. The building itself has a very interesting history. It was begun by Frederick Lundy back in 1934 in kind of a Mediterranean red roof style, which was eventually landmarked by the City Planning, by the Landmarks Preservation Commission in 1992. During the history of the building, it was operated as Lundy's Restaurant, which was a beloved institution in Sheepshead Bay. It was operated to the pleasure of thousands of individuals. Would often get 15,000 people on Mother's Day, 10,000 people on a weekend, and 2,000 people on a weekday. So it was a very heavily utilized site. In the 70s, the institution was closed, and the site experienced certain challenges in operation since then. Certain restaurants went in and out, the last one going out in 2004, which was Tam Restaurants. Tam had operated successfully the Boathouse in Central Park, and so came here, spent approximately $5 million in renovation. However, the restaurant was not successful and closed its doors in 2004. Cherry Hill came in 2007. And today, Sam and his colleagues and the workers here are really attempting to create and to maintain the business that is here. The Sheepshead Bay Special District regulations characterize this block as Subdistrict B. So Subdistrict B here, if we take a look at this illustrative map, really only pertains to our property. The only effective substantive change we're making to the Sheepshead Bay district regulations is for this block and this lot. So it's coincident with about 43,000 square feet of this lot. And what are we seeking to do? We're basically seeking to kosher the food store, no pun intended, in this building right here. So Cherry Hill Gourmet operates a food store on the first and second floor of this building. They operate on the ground floor. They have about 14,000 square feet total area with about, let's say, 2,000 square feet devoted to restaurant use or tables and chairs. And the retail use primarily appears on this ground floor. And then on the second floor, they have 6,400 square feet, primarily devoted to accessory uses, storage, office, etc. And that's the restaurant. So the special district regulations, again written in 1973, do not permit food stores at this location. And moreover, they restrict commercial uses, with the exception of certain commercial uses, as far as square footage and frontage. So all we are seeking to do with this special district text amendment is to allow Cherry Hill to remain here, to legalize this property. This application has had a past history. There's people in the community who have not taken to Cherry Hill in the past, and so this application had fits and starts years ago. There were other attorneys involved. Since our involvement here, we've talked to Sam, we've talked to his colleagues, and we've talked to people in the community who really want this to happen. As a matter of fact, I have over 65 consents that have been signed by people who live in the Sheepshead Bay district area. Sam has actually informed me that we now have an additional approximately 900 signatures. We're going to be bringing those to the community board when we appear on January 27th. So we are approaching about 1,000. They are not legal documents. They are not notarized. They are basically just a showing of support, evidence of how people now feel about this institution. So in short, because I don't want to take up too much of the time of the office, the special district here does not currently permit Cherry Hill to operate. This district text is narrowly drawn so as to permit them to operate at this site. And Sam and I would be happy to answer any questions regarding the application.
Thank you very much, Mr. Lobel. It's good to see you and your client, Sam. I wanted to just take this opportunity to ask, I understand that there are those in the community who believe that this site should revert to use consistent with what is permitted in the special Sheepshead Bay district, and that's the space remain well-suited to be returned to a restaurant.
Right.
Is that the case?
Well, we actually think that this text was written in 1973. The zoning resolution itself, written in 1961. This text was written in 1973. And in the course of applications at city planning, people are permitted under the charter to file amendments to the text. Times change and things change. So while we understand the feelings of the community and certain members of the community, because right now we feel very strongly about this application, we feel that the community board will listen to us and will hopefully pass us and approve us. But as far as this application is concerned, we don't think it's about the intensity of the use, because Lundy's at its heyday was operating with 10,000, literally 15,000 people coming in on a holiday. So it's not about the intensity, it's about the ability to creatively use a property for a use which now in 2015, is now better adapted for this area. Sam and I have talked about this a lot. We feel that this is a contributing business to the area. We feel it serves as an anchor for other businesses in the area in Sheepshead Bay. So while we understand that restaurant use was written into the text over 40 years ago, we feel that Cherry Hill Gourmet Market is now an appropriate use for this property now, and we feel that we're supported by people in the community, and it's no small thing to say that after Superstorm Sandy, where a lot of people were affected and had difficulty as far as getting produce and groceries and such, people in this area really relied on this market, and it really kind of affected the outlook on what the services that are provided here.
And so, as far as the property is concerned, is this owned by your client?
No.
Okay, so this application is coming not because the property owner is proposing it?
It is applied for by the subtenant, by Cherry Hill.
Mm-hmm. And the property owner is supporting this text change?
Well, we actually, we're required to get the consent of the applicant to bring the application. It's a non-ULURP item, and so we're bringing the application on behalf of the applicant to change the text. The lease, without getting into the legal issues, and actually I think probably we prefer to stick to the land use. We have the legal right to bring this application, and we filed the necessary documents with city planning.
And this was not possible at the BSA level?
Correct. We have made past applications to the Board of Standards and Appeals. We have made, or inquiries from the Board of Standards and Appeals. We've made past applications to city planning. There were previous attorneys involved with this years ago who were unsuccessful, and the community board did not appreciate this application years ago. We feel that times have changed, and that outlooks have changed, and that's why we feel that we have a strong application now.
And as far as this particular property, you mentioned Superstorm Sandy. I'd imagine because the bay is there,
Yes.
that this particular property was damaged?
Well,
This particular property.
And if you could just state your name as
My
well.
name is Samuel Littler.
Thank you.
I grew up in this area. I was born in Brighton Beach. Grew up going to Lincoln High School, playing ball. Worked in Brighton Beach making egg creams, if anyone knows who an egg cream is, if they remember. And from there, I grew up playing ball in Manhattan Beach, and I ate at Lundy's. To answer your question, Hurricane Sandy, most of Manhattan Beach, Brighton Beach, and this store were totally wiped out. We were told it would take us a year to open this store. We took loans, we borrowed money, and we opened up in 27 days. Brighton Beach was without power. Brighton Beach had their stores closed. And we became another location of availability to have fresh fruit, produce, and product available. We're not the only store with that. You've got Wallbounds a block away. Took them a little bit longer. They had some rough times. But we've worked very, very hard to become a good standing member of the community. David Asayev, the majority principal owner, came to this country, drove a van going to the market in Hunts Point, buying produce, schlepping it with his own hands and a hand truck, and built himself up in an honorable, dignified way. He opened up one store. This opportunity came along. He opened up a second location. We've worked with the community to become good standing, loyal members of the community. Look, I remember Lundy's. I remember all the drugs and violence that went on in the parking lot when Lundy's was closed. I remember the crackheads hanging out over there, the needles on the floor. And when they were forced out of Lundy's, they crossed the bridge into Manhattan Beach and went to the park, because we couldn't play ball there. I grew up there, so I know the story. No one can tell me differently. We've worked hard, we've worked honorably. We're not perfect. We've made mistakes. We've done everything in our power to correct those mistakes. Recently, a little over a year ago, I was invited to a dinner, and Bill Clinton was there and a couple of other people. I just want to quote him for 1 second, and turn the speaker back over to Richard. And he said very simple: we need a spirit of community, a sense that we are all in this together. Because when Hurricane Sandy hit us, it didn't hit Cherry Hill, it hit all of us. If we have no sense of community, then the American way will not be able to continue in a righteous way. And this was at a dinner, speaking to him, listening to comments with other people there. I'm a tremendous reader of old history of presidents. I've read what they've written. John F. Kennedy once said, "We are the American people. We build it, we strive for it, we don't give up, we continue, and we succeed." We're trying to move forward. We need the assistance of all the community boards, the city council, the Brooklyn Borough President's office. We want to do business in a dignified way. The product that we sell is a great product. We try to cater to all the communities in the neighborhood, and we hope that you look favorably upon our application.
I appreciate those words, and I wanted to just understand as far as the Superstorm Sandy impact, right? And I'm assuming you were wiped out and you rebuild.
Correct.
You had a choice to leave.
We had a choice to give up. The easiest thing to do is give up. We decided not to give up. We spent millions of dollars establishing the location. It cost us many more dollars to reopen. to rebuild refrigeration, floors, walls, product. You know, we have families to support there. We employ people with families that live in the local area. They don't live in a different part of the town. They live locally. They're in Sheepshead Bay, they live on Brighton Beach, they live on Ocean Avenue, they live on East 22nd Street. So they're living there. We're supporting
How many
people.
employees are there?
Depending on the season, between 35 to 40,
Okay.
sometimes 50, depending on the time of the year.
Sure. And as far as the square footage is concerned, the sub-district B,
Yes.
the text change is going to impact what would be the whole footprint. And what is the commitment as far as the preservation of restaurant space in the footprint of sub-district B?
Sure. You know, first of all, the text amendment affects the entirety of B. Right now, the text would permit Lundy's to remain open, and right now, there's a certain amount of restaurant use devoted to that site. The text right now, and we consult with city planning when we design a text amendment, when we craft a text amendment. The text right now would permit further expansion of the restaurant. We're not really interested in that. We have no intention to expand. We don't want to expand. I mean, we want to expand, but we're happy with the restaurant, with the food store as it exists, with the current breakdown, with the current restaurant seating in the food store and outside the food store, because there are seats, about 100 seats available in the summer and spring months.
That are provided by you
Correct.
as the food market?
Correct.
To encourage what would be patrons?
Correct. And we're happy to maintain that.
And you do not have what would be substation hot and cold meals being served?
What do you mean by substation? Like food areas where people can come in?
Correct,
No.
correct. Your food market does not, because I know that that's a model as well, as far as food markets are concerned. So you have no hot or cold food that are prepared on site that you serve?
We prepare food, we prepare food on site
As-
to serve. Right,
Okay.
what do you mean by hot and cold stations where people can self-serve?
Yes,
No, we
yes.
don't do that.
No, you don't.
We don't.
Okay. And as far as the second floor is concerned, that's going to be preserved as restaurant space?
Hopefully we can expand it on the restaurant.
Right now, it's not restaurant space. Right now, the second floor is storage, administrative, it's accessory use group 6. The restaurant use is right now on the ground floor. It amounts to something less than 2,000 square feet, and on the outdoor space. So there's probably a total of about 150 seats total, about 50 inside and 100 outside. And Cherry Hill is happy to maintain those seats.
And how are they going to be preserved as part of the text amendment change? Is city planning, is that part of the action here today?
It's not, but to the extent that we can work with city planning and work towards the preservation of those seats, we'd be happy to do that. I know that the zoning resolution is often crafted so that upon a certain date, the way that the building exists on that date is looked at for purposes of the text. We'd be happy to work with city planning and adopt that. That's great by us.
And are you working on language that you would be providing, or are they drafting that language? How soon are those
Well,
conversations?
We've had talks internally, because I've talked before to Sam about the fact that the restaurant seats are important to the area. So we've started crafting something internally. We have not yet consulted with city planning as far as whether or not this would require a formal amendment to our application. As a legal matter, I think that what we're proposing would be in the scope of what's already been considered, because they do environmental review of all applications. So since everything we're doing would be contained in what we've already established on the site, I don't think that they're gonna say this would require an amendment, but again, that's, I guess, for city planning to weigh in on. The only thing I'd say is that we're happy to do that.
Well, the city planning can modify.
Correct.
So I'm assuming that the language will, in good faith efforts between your client and city planning for the amendment change, to include language that can
Correct.
protect 150 seats.
We're happy to
Right?
do that. Yeah.
Okay. And so the parking lot associated to District B how would that be impacted? Will it remain in use? And what guarantees are part of the text amendment change to preserve parking space? Because I'd imagine both restaurant use and food market use require what would be the convenience of patrons to be able to have parking availability.
Right. The parking to the site, you're correct, is important to the operation of the restaurant. So I think as a technical matter, I'd first note that for the underlying zoning district here, it's an R5 C2 with the C2 overlay. For the underlying zoning district, we're maxed out on our floor area. So this building could not be enlarged at all. To the extent they wanted to enlarge into the parking lot, they wouldn't be able to for zoning purposes. For landmarks purposes, any enlargement would have to be approved by landmarks. It is highly unlikely that would happen. So we are fixed as far as this building is concerned and this site is concerned. However, to the extent that with our 41 spaces associated with the site, right now that's, there's people park off-site, and I know that people park at the El Greco Diner or former El Greco Diner. We're not seeking to do anything with that parking. We want to maintain that parking. We're interested in that parking. And whether or not it would be required to be adopted as part of the text or not, we'd leave that to city planning, but nothing's going to happen to that parking.
Okay.
We're not going to reduce that parking at all. It would be detrimental to the business.
Okay. And this zoning text change will not require any modifications to your site, construction-wise?
No.
I ask because we always make sure that we want to encourage what would be local hiring, local business contracting, and making sure that we're providing what is a local economy.
Sure.
And you being a local economy anchor to the community.
Sure.
But as Sam has just referred to, he does that already.
Correct.
So at this moment, I just wanted to take the opportunity to thank the applicant and Mr. Lobel for representing this project.
Sure.
I want to take a moment to open it up to the public. And I'd like to ask Councilman, you're going to defer? Okay. So Councilman Deutsch is going to be a gentleman as always and defer to the public. And so we're going to ask Ron Schweiger, if you could come up. He's the Brooklyn Borough Hall historian.
And if you could limit testimony to about 3 minutes.
Doesn't sound like he's sorry.
It's only for the camera. It's not amplified. It's just for the camera.
If I stand, it's all right over
Yeah,
here?
that's fine.
Or you could sit if you like.
It's all right.
You were
Rest. The way I was introduced, it sounded as if I was the Borough Hall historian. I'm the historian for the Borough of Brooklyn, appointed by the Borough President. Okay?
And now we're historian too. You give the tours here, don't you?
Occasionally, yes.
Yeah.
I give tours all over Brooklyn.
Thank you.
The site is a very historic site. As was mentioned by Mr. LaBelle, the Lundy Building opened in 1934. However, the original Lundy's was directly across the street, built on wooden pilings in the water itself, which opened in 1907. And in 1934, Mr. Lundy, and just to clarify, people who know the building, you know the initials, FWIL Lundy Brothers. Those are not the initials of the brothers. It's one man, Frederick William Irving Lundy. So I've seen it written that it's the brothers. It's not. 2 of his brothers drowned in a boating accident in the early 1900s, and he always kept the word brothers in the name of the restaurant. What we're concerned about is that this might set a precedent for other, as we say, markets to open up in the special zoning district. We don't want that to happen. Within the last several years, Coney Island has come back tremendously. It never was off the map, but baby, it's on the map now. Brighton Beach is going strong now. Sheepshead Bay is coming back strong too. We don't want to set a precedent, as I mentioned, where other markets, other stores would be able to come along in the special district along Emmons Avenue. This is wrong for Sheepshead Bay. if we go back a century ago, Brooklyn had the biggest and most popular resort in the United States. Brighton Beach, Manhattan Beach, Sheepshead Bay, and Coney Island. There were 4 major hotels, scores of smaller ones, Vaudeville Theater on Ocean Parkway and Brighton Beach Avenue. There were 3 horse racing tracks in Brooklyn. And Sheepshead Bay was part of this major resort area. People came from all over the United States and from Europe to Brooklyn, to our Atlantic Ocean shore. So Emmons Avenue was part of this, and we wanted to remain part of this. And I mean, a fruit and vegetable market is wonderful, but we don't want to set a precedent where the zoning is going to be changed so that it might open the door for more of these kind of establishments to open up on Emmons Avenue. And that's basically what it's all about. We do know that there are restaurants interested in opening up along that strip. And now that the recession is pretty much over, we're hoping that this is going to happen. Thank you.
Thank you. Richard, I just want to ask you, do you know the vacancy rate along what would be the avenue?
Sheepshead Bay?
Yeah.
On Sheepshead Bay Road today, we got about, 8, 9, 10, 12 stores vacant. Signs popping up every other day for rent, for lease, for rent, for lease. One just popped up today, right before the train station on Sheepshead Bay Road. You've got 2 restaurants for sale on Emmons Avenue.
Okay.
Because, business is not as rosy as it always seems.
Sure. Thank you. I'd like to call up Earl Barrison.
I'm here, but I'd like to defer my statement until others more important than me have spoken.
Thank you. Laura McKenna or McKinney? McKenna.
Yeah.
If you could stand up and get closer to the mic. Thank you.
There are 2 statements from 2 organizations that I'd like to read.
Sure.
Okay. The first is Garrettson Beach Cares, written by John Douglas, President. And both of these letters are addressed to Borough President Eric Adams. Dear Sir, I am writing to you on behalf of Garrettson Beach Cares. After reviewing with my board of directors the information about this issue, we have decided to oppose the zoning text change of the Sheepshead Bay Special Use District Section B for Cherry Hill at the Lundy's landmark site. We believe this precedent should not be set. The tenant in this case has ignored stop work orders, and what he is proposing will negatively impact other businesses in this area that are already providing those same goods and services. Signed, John Douglas, President, Garrettson Beach Cares Incorporated. Dated January 15th, 2015. The second letter is from the Manhattan Beach Community Group, also addressed to Brooklyn Borough President Eric Adams, dated January 14th, 2015. Dear Borough President Adams, Sheepshead Bay, with its fishing fleet, seafood restaurants, old-time yacht clubs, boating, anchoring waters, charter party vessels, and its recreational fishing fleet, has always been and currently is a destination. No matter where people live, the lure of the water and the fresh sea air makes Sheepshead Bay unique in our borough. It is a place to relax and enjoy a walk at the water's edge, a place to find all types of restaurants and watch as swans and ducks swim in the water beneath where you stand. Years ago, the Department of City Planning determined that this area was special, and they created the Sheepshead Bay Special Use District, called here Special District, in order to make certain that the ambiance of this unusual place was kept and not built upon in an inappropriate manner. Now you are being asked to destroy this special district by a tenant grocery proprietor, Cherry Hill, who has been operating illegally for many years in a landmark building that does not allow food stores. Cherry Hill has been cited numerous times by the Department of Buildings and the Environmental Control Board, thumbed its nose at the special district, and according to the Department of Buildings site, currently has a stop work order. As a law and order person, we assume once a police officer, always a police officer. You have the correct perspective about lawbreakers. No one is above the law, and no one should be bailed out as a result of breaking laws. In addition, the following are factors that should negate the granting of this zone-busting request. 1, in determining whether this site should be granted an amendment to allow for a food store, the issue is about the proper use of the building. 2, if it is determined that the special district needs a food store of this nature, so be it. However, there are an abundance of food stores within the Sheepshead Bay area, including 2 large supermarkets, a food market similar in nature to Cherry Hill, and other small food stores. Thus, the need for another food market is substantially diminished. 3, with regard to the use of
Ms.
this
McKenna, if you
building-
can wrap up?
Yes, okay, with regard to the use of this building, although the applicant wishes the world to believe that no other entity can use this space the space since a former restaurant went out of business, we call your attention to restaurants currently in the building that are and have been there for years. No one can predict the future. The reason Lundy's 2 failed was because of bad food, bad service, and high prices. The applicant has implied that Cherry Hill is more of a cafe and qualifies under the landmark designation. However, the second floor area with a capacity of approximately 15 seats and rarely has customers. Using this ploy is deceitful. The applicant's request to change the landmarked building for only a grocery business also states that at least 4 other sections of the special district zoning text will be changed for technical reasons. There's no information for the public as to what these technical changes will be. They are not specified in the public information provided, and no one knows what impact they will have. This applicant is also requesting modification of the frontage and the rear of the building. The application does not state the reason for this. However, in fact, if the current parking at the rear will be changed or reduced, or if some other use is contemplated, that should also be indicated. What will go on in front of the building must also be indicated. The text of the instant application strongly suggests that if Cherry Hill does not receive the approval requested and their business is forced to close, the building will remain vacant as it has been when the second Lundy restaurant failed. People within the community have investigated and found that there are national seafood restaurants that would be more than interested in obtaining this site
Ms. McKenna?
for a restaurant.
Thank you, I appreciate that. I'll
Signed,
take
Judy
that.
Barron.
Mhm. And I just wanted to ask you, with 12 stores vacant, have you seen or heard from businesses that are interested in coming in?
I'm reading on behalf of those organizations.
I see. I appreciate your honesty. Thank you.
Yeah, I can answer that if it helps.
Not now. 1 second. Steve Barrison, that would be?
Well, before you start that clock, because I have a statement too, I can answer some of the questions.
No, read your statement first, and we'll do that after.
Okay, I'm going to sit. It's a lot easier to sit,
Oh.
because I have answers to, there were a bunch of things made during that half-hour presentation that need some factual correction. This is to the Borough President too, and of course, I guess Madam Deputy Borough President, I did not know who would be here tonight. I'm an officer of the court, much like the Borough President as an attorney. Dear Borough President Adams, as president of the largest community coalition in southern Brooklyn, Bay Improvement Group, I've been an active leader and advocate, as well as BIG, which is Bay Improvement Group, for the Sheepshead Bay Renaissance over the last 24 years. I've personally been active with local civic groups since February 1983, devoting countless hours to Sheepshead Bay, the special use district, the community main streets, and our local small businesses. Where does one begin when it comes to following the law and the simple right and wrong? Is it a popularity contest, or does the democracy of our country, state, city, and Brooklyn follow moral and legal code? We believe the answer is simple and clear. The law must apply to everyone. We cannot totally disregard for human rights, zoning laws, building code, or other illegal conduct to then be swept under the rug and adjust the law just to make these acts retroactively legal. The application is plain wrong on its history. In so many places, we'll submit those comments later next week. With the sneaky rush-through process filed during the holidays, when the proper procedure should be to amend with a full variance before the BSA, as you heard earlier, instead a zoning text change is suspicious. But not surprising, because the applicant can never make the 5 findings by the BSA variance laws. However, the zoning text amendment, in the face of numerous stop work DOB orders, long before the applicant completed construction, now complaining about cost, it's really a self-created hardship, and it's clear as day. I've spent well over 30 years helping my community and many others around the area and the state. Sometimes you're successful, sometimes you're not, but never in all my years have I seen an application with such chutzpah to lie, mislead, and plain create a total sham before the city and the community as I see here. The great and only world-renowned landmark Lundy building is still recognized all over the world if you travel yourself. To somehow believe with a straight face that all the supporters of Cherry Hill who have zero knowledge or training in the special district use zoning would not love, welcome, and be happy with a good restaurant, hopefully seafood style, is laughable. Not only were several major seafood restaurants interested in the space over these years, I personally met with 2 more just this past Christmas who also were interested in the space in the great waterfront landmark Lundy building. In addition, I've spent hours in the community just in the last few months directly talking to customers of Cherry Hill in and about the Lundy building. Once they were explained the zoning and asked what if a restaurant were here, of course they all preferred the eatery and did not know about the laws. It's not a popularity contest, by the way. We learned that lesson with Little Moments. We brought 35,000 signatures and 15,000 letters and postcards and 500 people, and we were ignored anyway. Right now, Cherry Hill's in court. I don't know if you know that. They're being evicted by the landlord for owing almost $500,000 in rent. The landlord is sitting in this room right here. Cherry Hill has been in court with their prior attorneys, Cozen O'Connor, back and forth claims somewhere between $300,000 and $400,000. This is all public record. There are cases in the United States District Court over human rights and fair pay claims from their employees. There are about 6 personal injury suits just in 2014 alone filed against Cherry Hill. How can we alter the zoning text for a use that is completely contrary to the purposes and goals and the intent of the special district? The idea is for the waterfront zoning to complement, not the unique character, but not to compete with our Main Street shopping district, the many fruit and vegetable markets and numerous gourmet markets, all operating within 1 to 3 blocks of the waterfront. This illegal use directly violates that idea. The proposal, and I have been told directly through the local store owners, some are sitting right here, that since Cherry Hill opened illegally, their businesses have all dropped off 32 to 38% in the local areas actually zoned for this use. This precedent, above all, a special district use designed to last 150 to 250 years is disgraceful. It's a slap in the face to our laws and their meaning if this is allowed. If there would be no basis, no way to prevent anyone from opening whatever they want, wherever they want, be it a special, historic district, or just plain old regular zoning. We can all get together tomorrow, go knock down a bunch of houses right on Ocean Parkway, or in Brooklyn Heights, or Manhattan Beach, and we can put up a big IHOP, a large parking lot, and ignore the stop work orders, just like Cherry Hill did, keep on going, open up, complain how much money we spent, get lots of signatures from all those pancake lovers, and then, after 5 years, because they opened in 2009, according to the press, not 2001, I could submit those articles too if you'd like, and just get highly influential lawyers to file for a zoning text change. The owner of the Lundy building is on our big board of directors. I've spoken with him yesterday. He fully supports us and the goal of the restaurant in this space. He is also in court with the landlord to evict him. See, now you got 2 lawsuits going on. At the same time, the landlord for Cherry Hill, as I said earlier, is in court to evict Cherry Hill. Now, this makes things very complicated. What do we do here? To make matters worse, we are discussing and arguing over a use to obtain a certificate of occupancy. Well, guess what? Did you know that the temporary certificate of occupancy, which they're supposed to have to operate until now, does not exist? It expired. So that makes things even more complicated before we go forward and approve something like this. We are going to allow this to continue. The entire action should be thrown out. There isn't even a temporary certificate of occupancy. The zoning text amendment should be denied for so many reasons I would need 20 minutes to go through them all. So I'll finish up. Finally, I'm here speaking tonight for the 8 local established, respected waterfront organizations collectively known as POW, Preservell Waterfront. When Lou Fiddler was our councilman, it was 5. We've grown. Some have sent in statements. Some are here. Others will get them to you. And they had many conflicting obligations tonight. One thing is clear, that all 8 organizations representing several hundred people, from Bay Improvement Group in Sheepshead Bay, Palm Beach Civic Association, Gerritsen Beach Cares, We Care New York, Madison Marine Civic Association, Manhattan Beach Community Group, the New York Police Department 61st Council President, the Natural Resources Protective Association, we all strongly oppose the zoning text in a total unified manner. And if the owner were not in the middle of a lawsuit with his sublessee, the landlord, who was here tonight, he told me today he would write a letter supporting us and not in support of the zoning text change, which of course would be forever. There's no turning back. This was told to me by the lawyer about 2 hours ago. If nothing else, let us not make a decision. Let's not make a mistake on something so important to the future use along the special district, designed to last centuries, unlike any other kind of zoning in New York, not to be altered for one illegal, disrespectful operator. Let the owner of the building have his own say after the lawsuits are ended. The owner of the building is the most important player here, and he's in the middle of a lawsuit as well. The text change must not be permitted. You, as the leader of the borough, and of course the deputy leader, must stand for the basic principles of not rewarding this outrageous illegal violation of our laws. Now I can correct the facts. There were 4 or 5 little statements they made. So since I'm born and raised in the area, I figured I'd just correct it real fast. I already told you about according to press reports, I could send you the articles, they officially opened in May 2009. They said Lundy's closed in the mid-'70s. No, they actually closed in August 1979. The reason why I'm so smart, I actually have the entire estate file. So if anybody wants to see, Lundy owned the entire waterfront of Sheepshead Bay. That's why things were stagnant, not because nobody wanted to come down there. I can give you part and parcel from Sheepshead Bay Road all the way to Coyle Street. Every single property was owned by Lundy. He said he has 1,000 letters of support. Well, I don't know. I didn't see anywhere in the law that it's a popularity contest. We could easily get 20, 30,000. That didn't seem important here. He said Lundy failed in 2004. Let's give you facts on that. Lundy's was a successful run restaurant until Frankie and Jeannie, who ran it for the first 5 years, and Ron Schweiger will know too. Lundy's did a great job. It was wonderful. The reason why they failed is because they spent several $1 million opening up the American Cafe, and they personally guaranteed it, and it was located right by Ground Zero, and when something called 9/11 happened, they got wiped out. So then 2 other operators tried to run it, and they did a poor job. That happens. I represent restaurants for a living.
So, Mr. Patterson,
they
I
didn't
just want
mention
to
that.
make sure, I appreciate the correcting of the facts. I just want to get to certain questions that I needed answered.
Okay. And we're not gonna have 3,000 people there or 15,000. Nobody's ever suggesting that. The little corner at Cherry Hills would have 300, 400, 500, a couple hundred for catering. So, very doable.
So as far as your statement regarding the C of O, which has expired,
The temporary C of O.
the temporary
Yeah,
C
we don't
of
even
O
have a C of O.
was for a,
Well,
the
anybody,
existing C of O would have been for a restaurant.
that's correct.
So that C of O expired?
Well, you can't have a C of O for this kind of use. Richie could correct me. But then there was a temporary C of O,
But
which I have not
there's
read.
restaurant space above.
Yeah, I have
right?
not
So
read
that
it, but the
could-
attorney for the
If you could just
building.
allow me
Yes, that
to
is.
finish my sentence, it
Sure.
would help the dialogue. So the above space does have a C of O that is active for restaurant use?
According to the attorney for the building, I'm just relaying what he told me.
Where is the owner of the property?
That's the Pambrose, Pantelides Brothers.
But where are they? Do they have,
They're in court against the sublessee, Mr. Pappas, who then leases out to everyone else in the building. It gets a little complicated. There are actually 2 sublessees and then one bought out the other.
that's why we're here.
Yeah, it gets even more complicated.
Mhm.
But the problem is, you have all of that going on between them, where the owner of the building is the most important player probably in the whole game, and he wants to support us and yank it, but he's
He's
afraid.
not here.
His attorneys and I had a long conversation today, and they gave me permission to come here and say, as an attorney, as president, whatever.
But you
that-
don't represent him.
No, he
Okay.
has his own
So
attorney.
I just wanna understand, you said there's
They said the temporary C of O, which is all they had, has expired.
okay, so there's
So that means there's
no,
nothing right now.
correct, but there is a C of O that is associated to the second floor for restaurant use.
I'd have to see it, unless Richard or somebody has it, I'd be happy
And
to
if
read it
the-
right now.
And if there isn't any C of O in the first floor, at the very least, there's a C of O for restaurant use to the first floor space.
There must be
Because
some.
that's what it was, right?
Okay, putting on my lawyer hat, there must be some original C of O that's
Okay.
sitting there in the file.
Just wanted to make sure.
But
All right.
having not read it, it's very unusual to have our C of O compartmentalized sections of a building. It's usually for the building.
Sure.
And it lays out
But
those
you did
uses
look-
allowed.
You did look up the temporary C of O to know that it was expired.
No, the lawyer gave me his word.
So it's-
I only found out about,
I see,
boy,
so you're just. it's
about
like
4:30 today. I can
You haven't
easily,
verified yourself.
from the attorney, no. Unless he's lying, I could easily do a search. I'm sure Rich and I, one of us,
Okay.
can try to find out in the next few days. Is Department of Buildings here? Anybody here from DOB? They
Not
would
at
know.
all, the property owner isn't even here.
Yeah.
And so, as far as this application is concerned, the precedent issue is your concern as far as your statement?
Oh, it's everything. It's changing of the use. You're suddenly allowing competition with the community main streets and all those businesses. There's almost 12 businesses that,
In Site B?
outside of the special district where they're allowed to have that use. And all of a sudden, it was designed, the 2 streets perpendicular, the waterfront main street for tourism, recreation, all that, and all the other uses listed. Some are outdated, of course, everybody knows that. But the general concept of waterfront recreation is to complement that and not compete with the local community service main streets. All of a sudden, we're now introducing this large use, which is, by the way, even the use as existing would be hundreds of % larger than the allowable use anywhere else in the district except for a restaurant. A restaurant has this unlimited use. So even the uses within the special district are limited to 3,500 square feet. So if we suddenly were to allow 10 or 12 or 15 or 21,000, we're now going 6, 7, 800,000 square feet above what even allowable uses are allowed. So it gets pretty tricky. And 3,500 square feet, for anybody that can't visualize, is kind of like a drugstore. Sounds small, but it's a pretty big store. The average store in New York is 800 to 1,000, the mom and pop stores. You start getting into 3,500, that's a pretty good sized store. Now you're getting into much larger. The neighborhood Wallbounds is 10, 11, 12,000 square feet. So there's, square footage is bigger. So the impact is great. And you asked about Hurricane Sandy. Everyone here knows. There's nobody in this room that lives in Sheepshead Bay that doesn't know every single solitary business on Emmons Avenue was wiped out, including Sheepshead Bay Road all the way up to Avenue Z. So people in Hurricane Katrina are still figuring it out 7 years later. It's only been 2.5 years, and Sheepshead Bay's done a great job coming back. And Teresa, and we all know, and they're fighting. Some will make it, some won't. A lot of landlords took money when they shouldn't have, but I think
Before Superstorm Sandy, was there a vacancy?
very low. Even now.
What was very low?
Well, consider what did Richard say, 8?
12.
8 or 12, there's 135 stores at last count. I haven't counted in the last year or two, but there used to be about 135 stores just on Sheepshead Bay Road. So what is 12? I mean, it's very low.
And
In my head, I don't know what that is, 5%, 6%, 7%. It's lower than the usual rate around the rest of the city. Fifth Avenue has a higher vacancy rate, so does Madison Avenue.
you look at their vacancies.
Yeah,
And so, as far as the preservation of 150 seats,
those are temporary summer seats, so that's only about 5 months out of the year. So I'm not sure how that really helps the community. We went in there several times in the last month. There are anywhere from 15 to 19 seats on their mezzanine level, and I saw one person sitting there. When I went to sit down, I was told I couldn't sit there. They told me employees only. And my vice president was here with me when we went up there. I thought that was odd. But again, it's a temporary seating thing, and
Right.
first Richard said 100 seats, and then 5 minutes later he said 150 seats, and then by the end, Sam, we were up to 200 seats. So I don't know how many seats they have outside, but again, it's only summer, and it's temporary, and it can't be raining or windy or, so it's.
so as far as the site is concerned, you mentioned you had 2 different inquiries about the
Just since Christmas,
coming
right?
into what would be this strip.
Correct. Well, that space, their space,
But that space is not empty, that's
the Cherry Hill
occupied.
space.
How much space is there for those businesses to come in?
Where Cherry Hill currently is what they were interested in.
But that's not vacant.
Well, it's not vacant now.
So
You got
that's
2
not-
eviction proceedings going on. You got, almost $500,000 claimed on one, and the other eviction from the owner to the sublessee. So like I said, that'll all play itself out during 2015. It'll change everything.
And in the meantime, there's other spaces available.
Well, the Lundy building may have a couple of small spaces, but the major ground floor, is rented. You got Mazal and you got the Japanese restaurant. There's no significant space does anyone in this room know of space?
Well, it's not a public, it's not for
Okay,
public
I'm sorry,
discourse,
but I'm just
so
saying, we've all
please,
walked
the
up and down.
theatrics, we have to minimize.
No, I'm just trying to get the
Um,
facts out.
I
don't
appreciate
wanna
that.
be misrepresenting. If somebody can correct me, that's
I
fine.
appreciate that.
I haven't been there in about 2 days, so
Of
I'm
course.
assuming it's.
Yeah, just to clarify for the record, because I'm confused. Who's the owner?
Of the building,
Yeah,
Pambrose, George Pantelides, and Trevor.
and he is suing whom?
The sublessee,
Who is?
Steve Pappas, he's here, there's no secrets.
Okay. And Cherry Hill leases from Pappas, who leases from Pantelides.
That would be a good, simple description. There was another party involved, but it gets even more, they're out, they've been bought
But
out.
essentially, the 2 eviction proceedings that you're talking about now involve those 3 parties?
Correct.
Okay, just, it was very confusing.
You got
I knew
you
some.
got Cherry Hill
And it was confusing.
fighting against eviction, and then you got the sublessee, obviously, it's a ripple effect. Somebody owes a big chunk of money, then you can't pay.
He owes me, I haven't paid you, he owes me.
It gets down the road
Okay.
there.
Who signed the lease?
Which one?
No, the owner of the building leases the premises to I guess a middleman
No, I get it.
who
It's a great way to make money.
signed the lease with the owner, and the Cherry Hill signed a sublease with that guy. So they all signed leases.
Can I introduce you?
It happens pretty commonly in New York. Almost every big building has somebody hidden behind the owner from the sublist.
So this is a healthy business in a space that was subleased.
Well, we don't know if it's healthy. The
Madam Deputy
applic-
Borough President?
The applicant said
I'm
it's
sorry.
healthy.
We have Douglas Pick here as an attorney for Cherry Hill, who's dealing with a lot of the leasing and subtenancy issues. If you'd like him to address any of the factual issues, he's available.
I appreciate that
Okay,
very
sure.
much, thank you. I just wanted to understand, you're arguing the text amendment change is based on, and if you could finish that sentence, I would just appreciate it.
Well, they appear to be basing it on,
No, what are you opposing the text amendment change on?
it's a bad precedent, it changes the zoning.
I
It's-
just
it's-
wanted to
it's a
understand,
zoning
there was
cha-
a lot, so I
Yeah,
wanted
it's
to
like a
understand.
variance without a variance. Because they may say it's only one block, but it's in the most significant block across from the bay and the only landmark in this section of this entire community. Lundy's is world renowned, so it's hardly just some building. Lundy means a lot to everybody, and it still does.
Sure.
Go next door to Mazal.
Mm-hmm.
I was in there the other day, I don't know the guy, I finally met him, he's got these, I don't know what you call those, wash and dry things that
Mhm.
all over, he's got pictures of Lundy's everywhere, I introduced myself, and he goes all over the world telling people about his building and how proud he is,
course.
so the history, so
Mm-hmm.
it's all tied in. Sheepshead Bay's coming back, Brooklyn is hot, Sheepshead Bay was hit hard by Sandy, there's no question it's coming back, and Brooklyn is one of the hottest counties in the whole United States,
Mm-hmm.
so there's no doubt there would be interest in there.
Right.
I've personally spoken to representatives over the years of big national seafood chains, and I don't
Yeah.
mean Red Lobster, huh?
And what happened?
Well, Cherry Hill is there now. At the time before Cherry Hill, we tried, there was communication gaps between us and the owner, but now we all seem to be on the same page now,
Mhm. I'm going to just, for interest as a deputy,
right?
visit the area, because for me, it's not just about Site B, it's the whole community of the
Well, you don't have a
actual
single market there.
special district.
When you have markets a block, yeah, the first place to shop is 1 block away. The next place, we have an owner right here, a big market's 2 blocks away. You have a half a dozen smaller markets just within 3 blocks. And if you expand it a little further in the community, there are places on Port Island Avenue and other surrounding, all basically selling the same product. Is it a nice store? Sure. Is it a pretty store? Yes. Does it look good? Of course. It's a great Lundy building and a beautiful space. I mean,
Right.
it's just, it's the wrong place.
Okay,
You know, it's
Thank
one
you.
guy changing the whole direction of the community.
sure. I appreciate your testimony and the facts that you wanted to just correct on the record, and if I may, I want your testimony in my hand.
I will correct the rest in writing. There was
Absolutely.
one typo. I apologize. I wrote it by hand,
All right. Thank you very much.
and that's it. He made nice quotes from the president. Nobody could disagree with the 2 presidents.
Thank you,
so-
Mr. Powers. Ed Jaworski? Jaworski, I can see the I. Thank you, I thought it was a period. I apologize. From the Madison Marine Homecrest Civic Association.
Right, good evening, Frank Jaworski, I'm president of Madison Marine Homecrest Civic Association, and we're joining in opposing this situation. I'd like to submit 3 legal principles that I came across in play here that would appear to cause this application to be voided from passing and maybe even considered. 1, fraud vitiates everything. Fraud vitiates everything is a legal principle that once it has been shown that one party has lied or committed a deliberate misrepresentation, the whole case is thereby compromised and no longer defensible. 2, the presence of good faith. Following the questionable history and record of violations and thousands of dollars in unpaid fines, indeed requesting legalization indicates that good faith is and has been completely absent. I think it'll be a dangerous precedent to get involved in overturning the principle of good faith. And 3, this clearly is a case of spot zoning, which of course is illegal in New York State since there's no plan to support this proposal. For those of you not aware of spot zoning, a couple of definitions. It's zoning to the benefit of a particular property owner it's unjustified special treatment that benefits a particular property owner, if it is inconsistent, if it is not consistent with and furthers the purpose of the general area plan. So the question is, what's the general area plan? And as far as a text amendment goes, a local zoning authority, like a city, may seek to amend its zoning ordinance if it amends its zoning ordinance, but only for a parcel within a district and the parcel has a different land use characterization than the surrounding district, then it's an instance of spot zoning. And according to New York State and other states, spot zoning is illegal. The question of whether a rezoning text amendment constitutes spot zoning should be answered by determining whether the rezoning was done to benefit individual owners rather than pursuant to a comprehensive plan for the general welfare of the community. If the evidence reveals that the rezoning was not enacted to benefit the community as a whole, or was enacted without regard to the community, the rezoning will fail to meet the comprehensive plan requirement. So the question that needs to be answered is, what's the plan for Sheepshead Bay? Nothing to do with Sheepshead, with Cherry Hill or anything. What's the plan? We need to find out if there's a plan for Sheepshead Bay, and if it's not, this is spot zoning. Spot zoning is illegal. Open and shut place.
Thank you so much, Mr. Head. I'd like to call up Jack Spadaro, Vice President of Bay Improvement Group.
Hello, everyone. I too am a long-time and born and bred Sheepshead Bayite, also having gone to school there, owning a business there, and continuing with community service for the last 12 years. There is nothing wrong with a single entity business. This is a zoning issue, complete and utter one-case zoning. This is the reason why we're here. We all love a market, we all love food, we love egg creams. And I think the most important thing here is to understand that we want to preserve Sheepshead Bay. We're all here under a love for the area. We all have a lot of emotion, and you can hear it and see it in all of us. Just as we have historic districts around the whole city. If one of these districts is in danger, someone comes in and puts up an illegal business in any district and tries to change it after the business is running, it's wrong. And we need some more, I'm not going to say planning, but we definitely need some more official input into this. So I'm going to read my statement on behalf of the Bay Improvement Group. I am currently the Vice President. I speak on behalf of our members. We are the largest community coalition of residents and businesses in Sheepshead Bay area, and we are opposed to the zoning text change in our Sheepshead Bay Waterfront Special Use District. If this zoning text change is granted, it will set a legal precedent across our entire city for anyone in a special or historic district to conduct any business, regardless of the impact to that community. These laws were enacted for the purpose to protect and preserve our unique, historic, special use districts for generations to come, not short term. The applicant, prior to signing his lease, knew that this use was illegal use of space. He received many stop work orders and numerous violations from Department of Buildings, which continue today. The blatant disregard for our laws by ripping down these stop work orders and continuing and ignoring the zoning should not be rewarded by making an illegal use legal. In conclusion, if this zoning text change, as proposed, is further altered in any way, then it must be treated as a new application process to be publicly reviewed by our local civic and community groups. For the following, The will of the people and intent of our special district laws is paramount and requires that this text change be denied. Thank you.
Thank you very much, Jack. Do you happen to know, Mr. Spadaro, if there is any, thank you, internal landmarking, not just external?
No,
Okay. You don't know or you?
don't know it.
Okay, thank you. And as the lawyer to Cherry Hill, not the property, you wouldn't know if there's internal landmarking?
There's only the external side.
It's only exterior? Okay. Thank you very much, Teresa. Okay, so now we have Earl Barrison, or the councilman. You're going to defer? Thank you very much.
Can I speak first?
Yes, please.
My name is Earl Barrison. I have been a resident of Sheepshead Bay for over 60 years, so I think I'm pretty qualified to testify as to the character, which has been testified already. I don't need that. But I think the borough president should look at the calendar, which I have in front of me, which I assume was prepared by the borough president's office. And for item 2, which is what we're discussing, the last line says, to facilitate the continued use and legalization of the Cherry Hill. Now, this is an ambiguous sentence in a way. To facilitate the continued legalization? No. To facilitate the continued use, because legalization, it never was even pretended that it was legal. In fact, I'm a bit surprised that the applicant, in making its initial presentation tonight with its attorney and the applicant itself, made no statement whatsoever as to how this thing started, way back when. Way back when they began to build illegally and simply ignored the city's laws. As a lawyer, I'm sorry to say I'm appalled by what happened here. This has been said before, so I'm not going to dwell on it. But the applicant itself, in its project description, which is on file here, states that its intention is to legalize the Cherry Hill gourmet market, which means that the applicant itself recognizes that the way it's been operating has been totally illegal. The applicant itself says that. So how in the world, I must ask you this in all candor, how in the world can the city retroactively approve the illegal use and convert it into a legal use? The applicant may state and seems to imply, well, they spent millions of dollars in setting this thing up. What's going to happen to them now if they have to close? This is like the old story of a really old gag that the murderer of his parents now pleads mercy from the court because he's an orphan. It's a self-imposed hardship. This thing should not go on. It may be that in some fashion the district has in certain ways outlived its usefulness. I don't believe that, and nobody else who has a right mind believes it either. From the very beginning, the applicant has ignored stop work orders and simply had contempt for the law, had contempt for the district, had contempt for everyone sitting in this room who likes to obey the law. This should not be countenanced. It's as simple as that. I don't understand how this kind of conduct can retroactively be approved by anyone and said, go ahead, continue, because you have a nice market, because the fruit is pretty, because you supply a need, which really doesn't exist. We don't need this market any place in this area. We have enough food stores as it is. So what we're really dealing with is, in my opinion, a blatant, arrogant, and spit-in-your-face attitude without the slightest attempt to excuse the applicant's illegal disregard of our laws. About the only thing the applicant has implied to explain why it should not be entitled to is that it will sustain a great loss, which I've already said. That's no reason to grant the applicant's request to legalize what has been illegal up to now. I think enough has been said about this, except for one thing. Our laws are supposed to apply to all of us. This is what this country is based on, okay? And as a lawyer, I agree with that. I've lived with that all of my working life. The laws apply to all of us. There are no exceptions to that. Nobody should be permitted to ignore the law, get around it, simply because it did something illegal to start with, and now it pleads, help me out, which is what the applicant is doing. I suggest that the application be denied in all respects.
Thank you very much, Mr. Barrison.
Thank you.
Absolutely.
I'm asking you this question because I meant to ask it earlier, but I don't know. Has Sheepshead Bay Plum Beach Civic taken a position on this at all? Do you know?
Yes.
I have full authority from Cliff and the board, who was supposed to be here.
And will they be submitting,
Since you have the authority, it's a no. They're against it.
There it is, of course. That's where the 8 power groups come in.
Okay.
going to be submitting any testimony on that position?
Well, the POW submission I made is for the 8 groups. You have received 3 or 4.
Correct. And everybody has submitted individual from each organization, so I was wondering if they were going to submit their own as well.
Well, 1 or 2 may not. The others said they would get to it between now and
Okay.
in the next week.
And so they'll get it to us. Okay. Thank you, Mr. Barrison. I appreciate it. Councilman, it's your turn.
I'll be very brief because it's getting more confusing as time goes on. So, basically, when Mr. Lobel mentioned spoke about the building, he said our building, but it's not really our building. It's Lundy's building. The building is approximately 48,000 square feet, and the tax amendment is basically for the 48,000 square feet, and that's for sub-area B.
Well, that's what I was asking before.
Yes, it's for sub-area B. So I am opposed to this tax amendment because if it's to help any individual business, this is actually, this tax amendment is for entire block and lot, which I don't think there's a reason to go and do a tax amendment for an entire square block for sub-area B. So I am opposed to this specific tax amendment as far as what they're asking for.
I appreciate that.
Yes.
And will you communicate, this is not going to go before the city council?
This will be going in front of the city council, and actually there was the first community board hearing was supposed to be December 15th. It was pushed back by the applicant. I really didn't get too much notification about what's going on, what this is about, and then it was pushed back again. And I think like someone mentioned, Jack mentioned, that it needs more professional and community people getting involved and to really take a look at this. And moving forward and going now in front of Borough Hall and then the community board following, I think, the 25th. The 27th, this is really.
And it's coming before the city council when?
It's, we're not sure yet.
To be determined.
Yes, yeah.
And so there's no time clock?
City Planning Commission does not have a clock.
Correct.
Yeah.
So you have an abundance of time to be able to get what would be.
Today's, this tax amendment that we're discussing right now at this meeting, this hearing, I am totally opposed to this.
Okay,
And everything else is up for discussion.
okay. Everything else as in what?
As in anything further, but this tax amendment I'm totally opposed to.
So you're going to be communicating to the City Planning Commission?
Yes, I will.
Okay, all right.
Yes.
Okay. Thank you. I appreciate it.
Thanks.
And this concludes what would be item number 2, unless there's anyone else.
Madam Deputy Borough President, will we have an opportunity to rebut any of the comments that were made, given that we are the applicant in the application?
In writing, you could submit.
In writing.
I would appreciate,
Could you tell us where to submit a written statement to?
of
again,
course,
Please.
of course. You can go to Ask Eric at Brooklyn BP,
Brooklyn BP?
B as in boy, P as in Peter, .nyc.gov.
And if you'd like mail, our address is 209 Geralman Street, Brooklyn, New York, 11201. But obviously, you could, even if you write it, you could attach it to an email to the Ask Eric email.
Thank you very much.
Thank you.
And so if you can do the same as far as any refuting of the facts?
I also just reiterate that in case there were any questions that might be clarified tonight, just a bit.
available, but it's obviously.
And if you could leave your contact information, that would be fantastic. Thank you very much.
Thank you.
I appreciate it.
Sorry, is there any way I can say something? I'm the sub-landlord.
If you'd also sign a speaker slip for us?
Okay.
Richard, I closed the item. Right. Did you sign a slip?
No, I didn't.
I was asking where were all these individuals that were mentioned. So if you could sign in a slip?
Okay, yeah, sure.
Thank you very much.
If you have any questions, call me.
I appreciate that. Right, I had already said we were closing because we had no one else. Right. Afterwards, can you get the rest of his information? Mr. Pappas, if you could come up.
Okay, sure. I say here or what?
You could sit in front of the microphone.
My name is Steve Pappas. I'm not the owner, but I'm the, I guess you might call sub-owner. I leased the space some years ago, 20 years ago, actually,
In what year?
in 1994, which is about 20 years ago. And I signed a 49-year lease with the owners. And when I signed
The owners who were?
the owners were, it's called Sheep's Head Restaurant Associates.
And are they still in existence?
Oh, yeah, they're still my landlord,
49-year lease.
49-year lease. When I signed the lease, anybody who lived in the area should know that the building was really boarded up. They already discussed, they said that. However, my associate and I, we signed the lease because we felt that it was a beautiful building, and even though the landlord did not know what to do with it, it was boarded up after they bought it for about 10 years, we took the block, you know, we made a big investment to open up the building, and after 20 years, now that finally I put the building in a good order, and whatever everybody said about the Hurricane Sandy is true. I mean, we were the first ones to open the building, like they said, in 27 days or whatever it was. It's true. We were the first ones that we spent the money right away to be able to open up the building.
And
The
Mr.
di-
Pappas, if I
Yes.
could just ask you a question. You began your lease for 49 years in 1994.
Yes, 20 years
20
ago.
years later, you are subleasing.
I still-
20 years ago, were you aware of the restrictive use?
Yes, I did.
Okay.
Yes,
And you made that information available
correct.
to
Yeah,
the...
everybody.
So did you know that this use was not going to be a restaurant?
No, yes, no, I knew what they were going to do.
Mm-hmm.
However, our lease specifies that you have to, you know, comply with the zoning laws. And they had an architect that they really got, believe it or not, nobody said it, but they got approvals from the building department to do what they want to do. And then for whatever reason, the building department went there, and they said, well, look, you said you're going to put more chairs, you know, and you didn't put them, therefore, you know, it still continues to, you know, it's an illegal use because it's not a restaurant. So since then, though, I must say that they're right, they spent millions of dollars, and they hired the right people to really change the zoning or the text.
But were you aware that the use was not a restaurant?
You mean their use? Yeah, of course. I knew that they were going to do a supermarket. However,
Was that the legal use?
no, it wasn't. However, they say just when you make a lease to somebody, say, look, you do whatever you want, but you got to obey the zoning laws. And they did. You know, they went to the building department, and they designed the restaurant to be, in a way, restaurant. And they, as an accessory use, they would sell also products. The actual zoning says that it should be an eating and drinking establishment. Now, depending how everybody really explains they explain what that is. It could be, I mean, a supermarket is also an eating and drinking establishment. Well, I know it's no, but that's why they designed the place to also have a restaurant in it. As a matter of fact, half of the space is really a restaurant. It's the kitchen. The kitchen is so big, which is part of a restaurant.
I specifically asked if there was substations for self-serving
Well,
or...
they answered
and
that thing wrong.
It's not.
Well, it's not, but they have a kitchen in there that is the
That they
biggest
prepare
kitchen.
food.
They prepare food, beautiful food too, and then they sell it. They either sell it through to the people to take home, or they sell it, they offer it to a table and the people that go sit in these, seats and whatever have you.
They sit where?
Well, they have areas that, it's like a restaurant that people sit and they eat. On the mezzanine, and they mention about the outside. And when they realize that, well, look, we got to do something here because we cannot get a TCFO. By the way, the question that you asked before, do we have a CFO? The answer is when you go in and fix a building, automatically the CFO goes away, and now you get what they call a TCFO.
But you got that on the first floor, not the second floor.
On the whole building, no, on the whole
The
building.
whole building.
We had
all of Site B.
All of Site B, we
So
had it.
none of those businesses in Site B has a CFO.
No, the CFO, when you change a building, automatically the whole CFO goes away, and now we get what they call a TCFO until you finish the whole building. So we did that, but we
So the whole building is in violation.
then we lost the TCFO for other reasons. It wasn't really the fault. But then when we tried to get the TCFO back, the building department says, we can't even talk to you because you have a non-conforming use or an illegal use. And we try since then to get this conforming use by the change of the
And
zone.
the other businesses in Site B have now their TCOs and COs?
Well, they're operating even without a TCFO, because the building department, once they take the TCFO away, that doesn't mean that
But
it's
they're
illegal.
You're in violation.
You're in violation, but they don't.
You can't operate without a
Well,
CFO
not
or
true.
TCO.
No, not true, because if you cannot operate, why don't they close them down? The building department doesn't go and close business down just because there's no TCFO. There's a lot of buildings that there's no TCFO. In other words, if you lose it, for whatever reason, the building department still allows you to work it out until you clear those violations and until you get the TCFO. And this is really what they're trying to do. And I, as an owner, I mean, as much as I understand what the rest of the people are saying.
As the leasee, the
As the
tenant.
lessee, let's say that I'm the owner.
You're not the owner.
I'm
You're
not.
a leasee.
I'm saying as a lessee, for the 49 years, I am the owner. So for the 49 years, I control the site. What I'm saying is, when an owner has a building and he cannot use it as only a restaurant, because we try very much to let restaurants in there, and for some reason, they wouldn't happen. They went out of business, they spent a lot of money, then we brought another one. And what I'm saying now is, assuming that I'm controlling the place now for 49 years, I'm really in best shape here, because if they go out, what do I do? Well, yes, they say that I can bring other restaurants, but what if it takes 2-3 years to bring other restaurant in there? And then I'm being hurt as a person controlling this building. And this is really all I want to say, that I'm not, it's not a matter whether I support them or, not supporting
You
the other.
control
Yeah.
Site B
The
in
whole
its
building,
entirety.
The whole building, yeah. the whole
And so,
building.
are you in court in a lawsuit?
Okay, what happened now, because of this thing, the main owner, he sued me that because I have a non-conforming, a tenant who with a non-conforming use, he wants
He
to
didn't
evict
know
me.
that.
Oh, he knew that also. By the way, when we made a lease with them, they also agreed to sign. Yeah. Both the owner and me, the sub-owner, we approved, the use that they were going to use. However, again, in the lease, and it's very simple, you can read the lease, it says, yes, you can do it, but you have to comply with all the regulations, the zoning laws, and blah, all that stuff. So, obviously, again, They did get the approved plans, but then something went wrong, they changed some things, and then the building department took away the use, and now they call it an illegal use. So what happened now, the owner is suing me to evict me because I have a tenant who has a non-conforming use. And we went to the court, and Judge Demarest said to me, well, look, the owner is right. So the only way that you can resolve your problem is to evict the tenant. And right now, I'm in an eviction proceedings with the tenant. However, if I do evict them, it's not that I did the best thing, because what do I do now with this space? I'm gonna lose a lot of money because they pay me good rent, and I will be
So
hurt.
it's not in rent arrears?
Well, they are also in rent arrears, but that's a different story. I mean, they claim that,
So your housing court, your court case is not in relationship to rent arrears, it's
No.
in relationship to,
to non-conforming use.
Correct.
But also, we have a lawsuit against them on arrears because.
Separately.
Because they say, I mean, I charge them for,
and so they've been served.
yeah, we are in court.
For the
Actually,
arrears.
we're in court today,
Mm-hmm.
earlier today, we were in court. But again, that's immaterial. My main concern is, can they get this conforming use or this change, which will be good for me? And that's what I'm saying, that is a, yes, yeah?
Sure.
How about other business?
I'm sorry?
How about other business?
What other
Lou.
business?
Around the
Excuse me, if we can control the outside public comments, so that way we can have a dialogue that's going to allow for a question and answer, I appreciate that, thank you. And if you want to testify, you should sign up.
Why not?
Thank you.
So, if this application were granted,
Yes,
it would no longer be a non-conforming use.
correct.
It would end both your lawsuit and the landlord's lawsuit, the owner's lawsuit against you.
Correct.
Okay. And would it be fair to say that the owner's lawsuit against you on the non-conforming use, because I can't really figure out any reason why that would matter to him,
Well-
is probably because he wants to take you out.
To make more
So
money.
he can have a better deal.
Yeah, to make more money. Oh, that we know. You're absolutely
Now we-
right.
Now we
I mean, the real reason why they're suing me is because if they get me out, they will be getting 3 times more rent than they're getting from me right now. And they're doing this, and I'm fighting
And
them.
they're using non-conforming use.
Yeah, as an
their
excuse,
hammer.
correct,
Got it.
as the hammer. And at the meantime, I have spent over $1 million in legal fees, and they're still trying to get me out. I'm trying to work with the tenant and say, look, try to do something so we can all,
So you're not actually against their application?
not really, because, because really, I mean, we tried the restaurants for a long time, and I realize what these people are saying, that in that area is a special area that we should obey by what, the area says that it should be. But it's not that we didn't try. We brought in 3 different restaurants.
Have we met them all?
Okay, so, and they just went out, and then when they came along, initially I thought, well, look, if they do the actual plans, that they're gonna be able to make it look like a restaurant, but also they can sell things, and that was the idea initially. We thought that it was a good thing to do, but then it didn't work that way. So now we're trying to really resolve, the different problems that everybody has.
I appreciate your
So-
candor,
Yeah.
Mr. Pappas, thank you.
Thank you.
And we have Ali Yukank, an owner in the area as well, Bayfruit.
K. U-K-U-N-C. Yukank. My name is Ali Yukank. I'm owner of the Bayfruit Corp, 1717 Avenue Z, Shipstead Bay Area. I'm that neighborhood since 1995. Until 2006, I was at the East 16 corner, 11 years. I lost my lease. I got my new place, which is 2 blocks away, same street, Avenue Z, 28,000 square feet. I never think I'm gonna go that big open, because I don't have that enough money. So what happened was my reputation, I don't even know. When I started, Ali, don't worry about it. Don't worry about it. I opened the store 6 months later, and I built myself, A to Z, except electrician, plumbing, other construction, sheet rock, shelving, tabling, everything. I did myself.
Are you in the special district space?
Yeah, I'm around the block, yeah.
Around the block,
Yeah.
away from?
So owner of the Cherry Hill used to be wholesaler. I remember I used to buy from him. Suddenly, he decided to open retail.
I see.
Year 2000, or I don't remember, 99 or 2000, he come to me. He goes, Ali, I did good or bad, I have no idea. I rent a store, I don't know what to do. Me and my partner, we went to his store, which is another store, he's got 86th Street. We built his store. We set up everything for him. Back then. Then 2006, I lost my lease, it's 16 corner. I got new place, it's 18 corner, which is 28,000 square feet with the parking lot. Closing area, 20,000. So barely we made it, and I don't even know my reputation. Anybody I call, I leave for you, no problem. I opened the store, my gap is $1.7 million. I'm struggling, I'm still struggling to pay. And 3 years later, Cherry Hill owner come to me, my office, with the one Azerbaijan guy, his friend, whatever. I was thinking he can stop by, say hello, congratulations or something, or good luck for new business. The first thing he sit down, before I offer him any coffee, anything, he asked me, I need this place. Take your stuff, I give you $400,000, just walk away. And as soon as I hear that, I kick him out of the store. 3 years later, he come next to me. He opened like as a competition. And he's still doing illegal business. Anytime, this is not my first business. Like I did like 7 different locations. Before I rented, I want to make sure the certificate of occupancy allowed to run this kind of business. I don't understand how they did that. I have no clue. I'm listening almost more than an hour. I'm start shaking already. I still got the gap, $400-something thousand left. And they was worried about the 30, 35 employee. What am I gonna do? 81 employee. Okay, since the Cherry Hill opened, he took away my 30%. Okay, if a certificate of occupancy is saying that you can run this type of business, more than welcome, competition, I understand. I understand very well. It's bothering me, every little thing, summons, pay, court, pay. I don't mind. If I did something wrong, I would like to pay, why not? If I'm wrong. But it's day one, they wrong. Starting the day, first day, beginning day wrong. What kind of law is this? What's going on? I mean, I'm start shaking. I have struggling $62,000 a week payroll I have. 80 people, wife and husband, 180, 160. Couple kids, over 300 people. I'm feeding right now. And I'm struggling to pay my $424,000.
And your space is legally
Legally,
occupied.
exactly. And I have 81 employees. I'm not worried about 35, 81.
I appreciate the time you took, Mr. Ali, to testify.
Right,
And we have you on record,
yes.
and we will take your comments into consideration.
I'm sorry to interrupt you. Enough is enough. Enough is enough. I got up to here. I got up to here.
I understand. And thank you for coming.
No problem.
I appreciate it.
Thank you.
Okay. So this item, if no one else is going to be testifying at this moment, I'm going to close this item, and we will move to item number 3.
Calendar item number 3, 140209 ZSK.
This applicant, SO Development Enterprises, LLC, seeks the granting of a special permit to allow a new building to be constructed to contain a commercial use, and that side yard building restrictions in effect when the side yard lot line also serves as a rear lot line for adjoining residential lots, be waived in order to facilitate a 3-story warehouse building. If you could take the conversations outside, I would most appreciate it. Thank you.
Thank you.
Thank you very much. In order to facilitate a 3-story warehouse building in the Special Coney Island Mixed-Use District, Community Board 13 has not voted on this application yet. I will hold off on making any decisions until I hear from the board. Would the representative for this application, Joshua Reinsmith, please state your name for the record and present the application?
Good evening.
Good evening. Thank you for being patient.
Absolutely, absolutely. I'm a little offended I don't have any fans here, but
Good night.
My name is Josh Reinsmith. I'm from the firm of Worshall-Burstein, appearing tonight on behalf of SO Development Enterprises, which is the owner of 2 tax lots on West 15th Street within the Special Coney Island Mixed-Use District. SO Development Enterprises is actually an affiliate of a long-standing business in the Brighton Beach community, St. Petersburg Global Trade House, which is a retailer of Russian literature, books, music, as well as souvenirs. They have a retail space on Brighton Beach Avenue, right at Brighton First Place, as well as a space on Kings Highway and a place on Fifth Avenue here in Manhattan. Currently, St. Petersburg rents warehouse space within East New York. However, all of their employees are based in the Brighton Beach, Coney Island neighborhoods, and so they're looking to move their distribution center to a place that is closer both to their retail stores but also to their employee base. The application we filed at the Department of City Planning and is now before the City Planning Commission is a special permit to permit the construction of a 3-story warehouse building within the Special Coney Island Mixed-Use District. The Mixed-Use District was originally enacted back in 1975 with its primary purposes of realizing the mixed-use character of the neighborhood and preventing large-scale businesses and residential developments from coming in without any approval from the city. So in that connection, or in that regard, I guess first off we'll talk a little bit about the mixed-use district, its boundaries. It's generally bounded by Stillwell Avenue to the east, Cropsey Avenue to the west, Hart Place to the north, and then I believe it's Neptune Avenue. It is a industrial area with residential mixed in. As I had mentioned, the property is located on West 15th Street, just south of Hart Place. West 15th Street is a one-way street that travels in a northerly direction. Hart Place is a one-way street that travels westerly toward, Cropsey Avenue. The special district regulations basically maintain that no development can take place on this site absent a special permit, whether it is for a commercial manufacturing development or for a residential development. And the reason being is no permits can be issued for any type of building on lots that have more than 60 feet of frontage or 7,800 square feet of lot area. The subject site has 147 feet of frontage. As you can see, it's actually a very uniquely shaped site, pretty much triangular. So we have filed a special permit, one, to permit the commercial development, but also, in addition to that, the special district requires a 15-foot side yard or open area to be maintained along any portion of our side lot line that adjoins the rear lot line of a residential use. So as you can see on this site plan here, the 15-foot open area requirement would be required along this entire lot line. This portion of our building is the portion that is within the 15 open area requirement. The business actually has about 6 to 7 people that are employed in the warehouse function. The amount of truck traffic that is brought to, I guess in terms of the current warehouse facility in East New York, there is a overnight courier delivery in the morning and one in the afternoon, and it generally has a significant truck delivery less than once per month. We're unable to utilize larger trucks on West 15th Street, and they're unable to maneuver into the building, and so we're going to probably be having one 20 to 26-foot truck delivery per week at most. That's essentially the entire application. I'm happy to answer any questions you may have.
I appreciate that. Thank you very much. I wanted to just take a moment to ask you, the applicant for this is a property owner, is the property owner.
She owns the property, that is correct.
And the property up to now has been what?
Okay, thank you. I should have clarified that. So the property has been vacant for at least 10 years. One of the lots has been vacant for 10, another has been vacant for 15 years. She purchased the property in 2008. Currently used for automotive storage. And as I mentioned, nothing can be filed, no buildings can be constructed due to the special Coney Island district regulations. The underlying zone is in M12 zoning district, and the building fully complies with all M12 bulk regulations.
And as far as this particular building, vacant for so many years, the property owner wants to bring what is a leased building to be able to, in East New York, is it leased, the building?
Yeah, she leases warehouse space in East New York.
So that now that building operation will no longer be part of her footprint.
Exactly.
And she's trying to consolidate her business so that there's closer proximity?
Yeah, only from a geographical standpoint,
Correct.
not in terms of business size or anything. It is going to be the same operation, just closer to her retail establishment, her main retail establishment.
And the warehouse in East New York is where? The address?
I believe it's Snedeker Street. I don't know the exact address.
If you could get that to us,
Absolutely.
that would be most helpful. I would most appreciate that.
Sure.
And I understand that when the community board held its public hearing, there were community board members who expressed concern regarding additional truck traffic that would be introduced to West 15th, a street that has some homes, and you referred to it, on Hart Place and Neptune. Your response as you presented, was that the solution to what would be this concern, or is that what you already have proposed to the community?
We had proposed, discussed the exact same presentation. I believe a lot of the community's concerns, or a few of the community's concerns, were that they didn't believe the truck could maneuver into the loading berth. We've had our architect look at that. They've put together turning diagrams that show a 26-foot truck can maneuver into the site. And they've actually been submitted to city planning in connection with the environmental review of this project. And if the 26-foot truck doesn't work, we would have to adjust into a 21-foot truck. But the actual level of truck traffic, as I had mentioned, is very minimal. One per week, and that may be even conservative, and that's what we included in our application, but it's probably likely to be less in terms of deliveries coming to, mass deliveries coming.
And what is the product?
It's Russian books, magazines,
Right, you mentioned
movies, music, any type of Russian souvenirs. Also, a lot of Russian porcelain is sold out of their retail space on Fifth Avenue.
And as far as the use of waterways, is the creek an active creek for barging?
I do not know.
And that has not been explored?
That has not been explored. We have no use or connection to that. We don't have any ability to access the creek.
But that doesn't mean that. And so, as far as this property is concerned, has the property owner witnessed what would be Superstorm Sandy surges onto the property?
She's been there since before
Right, but was
Sandy,
there
so
a surge?
I don't know.
Okay.
In terms of compliance with zoning resolutions, floodplain regulations, we do have a cellar. And then our ground floor will be at flood resistant construction elevation, which is 1 foot above the 100-year floodplain. And the only uses in the cellar will be for storage. Under the building code, I believe the only uses you can have below floodplain are going to be storage and parking. And we will be using it for storage. Originally we were going to design our mechanical equipment to be within a watertight room in the cellar, but I believe the 2014 construction code has changed that, so we're going to have to reconfigure some of our mechanical.
And you're in the process of doing that?
Yeah, our actual structural plans and mechanical plans are finalized. This is the first step in the process.
And this is an empty lot?
Vacant lot.
That you're...
There are actually 2 tax lots.
Right, you're coupling.
Yes, one is used for automotive storage. This property here is an automotive storage yard as well, and that continues. My client rents space to the store vehicles. And this property here is a tax lot that she actually just acquired, and that's vacant, and it's not used for anything.
And so she's going to be constructing?
That is correct.
And as far as the construction is concerned for the use permissible in that tax lot that's combined, has there been any exploration for further than what would be storage use? Light manufacturing?
She has not. She's owned these properties and she's had this need for storage. And she's owned them for quite some time, so that's really all she's considered.
And so, can you just share why is the building configuration being requested in lieu of configuration that is pursuant to zoning?
You're talking about the 15-foot open yard waiver? Okay, so under normal M12 zoning regulations, this building would fully comply. No side yard is actually required. In this mixed-use district, an open area is required along that portion of our side lot line that abuts the rear lot line of any residential uses. So these buildings here are residential. This is our side lot line, which abuts against these buildings' rear lot line. So a 15-foot open area is required along this portion, just this portion of the property. As you can see, the property is very uniquely configured. And this area down here is the one that has the least utilizable open space. And so the goal is to put our stair and elevator core on this portion of the lot because it frees up the rest of the open area on the larger and deeper portion of the building. If we were forced to comply with the open area requirement, it would shift our core either into the center of the building or in the alternative to the other side of the property, which is the property that has the most open space and is most efficient for our storage needs.
Just to clarify, so the corner property, the 2 highlighted figures there are for the corner, then you have the 3 in a row. So all 3 in a row are homes?
They are 2-family homes.
And the way you have the shading, it doesn't quite reflect, so the yard area, so because you have no building in that little corner, that's why that's not a shaded object.
Yeah, exactly, I'm sorry. This is actually an open portion of the property, no buildings here. We'll have 2 parking spaces, which are what are required under zoning.
Thank you. Okay, and moving forward, it's the Borough President's policy to promote the use of sustainable and renewable energy resources focused on advancing a sustainable future in Brooklyn. Additionally, excess stormwater has resulted in flooding in the area of Coney Island, where the site is located. It's Borough President's policy to promote policies to retain storm runoff. What consideration has your client, possibly in consideration with Department of Environmental Protection or the Mayor's Office of Sustainability, NYSERDA, NYPA, taken towards incorporating solar panels and or a green or blue roof and bioswales as part of the sidewalk paving plan?
First off, in terms of sustainability, I'd like to start in terms of we're bringing our distribution center much closer to the employees that work there, as well as the retail uses that it serves. So in terms of reducing traffic from this site to East New York, it's one sustainable measure. With respect to solar panels, it's actually something we're very much in favor. It is going to be a matter of economics as to whether we can make it work. The reason being is we don't have a lot of open roof area, and a significant portion of that, which is the first floor roof in the back of the lot, could be impacted by the 3-story portion in the front. And so we're not going to get direct sunlight on this portion for the entire day. It's something that we're certainly investigating, and if it's something that we find can work, we're open to it.
If the structure is done in such a way where even if the panels are not part of the initial build-out, the fact that if the structure is designed to accommodate a future change, it's something to also consider.
Sure, and we're committed to that, and we'll investigate that. We're also committed to investigating the feasibility of the bioswales, collecting rainwater and then feeding them into a system. I spoke with the project architect, and he's very in favor of working on a design, working with the city agencies to see if this is something that's feasible.
Okay, no further questions, and you see we have no speakers.
Great, thank you very much.
So, actually, one last question.
Absolutely.
Borough President's policy is to maximize job opportunities for Brooklynites with local businesses. If you could outline what steps have been taken or could be taken to ensure the inclusion of minority and woman-owned business enterprises and local business enterprises in the process of the construction.
Absolutely. So first off, my client is a woman-owned business enterprise who's based in Community District 13, where this warehouse would be built. But in terms of the construction of this facility, we're anticipating at least 50% locally based business enterprises is actually doing the construction. And within the borough of Brooklyn, I would say that figure is much higher. We are also committed to working within the guidelines for minority and women-based business enterprises for hiring. I don't know if our general contractor necessarily will, although we're going to open the bidding to that, but we will work and are committed to taking commercially reasonable efforts to ensure that we meet or exceed the recommendations under current local law.
Okay, thank you so much. No further questions.
Thank you very much.
Okay, the hearing on this item is now closed. Thank you for participating in this public hearing. The Borough President will review the applications that we heard today and will soon submit his recommendations to the City Planning Commission. We'd like to take this opportunity to remind you that the City Planning Commission will hold a public hearing on these items. Hearing is now adjourned. I'd like to remind those who are viewing on the website that timely comments can be submitted by email to askeric@brooklynbp.nyc.gov. Thank you.